Hello friends, today we are going to talk about changes in Section 6 of the Income Tax Act which are brought in by the Finance Act 2020. These changes are going to have far-reaching implications for taxation in India. To talk about these changes, we have with us Mr. G.C. Srivastava, who is an advocate with High Court and Supreme Court of India. He has rich experience of about 50 years with taxation in India, which includes 37 years with the Income Tax Department, where he was ex-IRS officer. With the Income Tax Department, Mr. Srivastava handled various roles, which included Director General of International Taxation. He was part of the policy-making team of the Income Tax Department. He was also Competent Authority of India, and he was the chief negotiator of many tax treaties for India. Before the Supreme Court and the High Court, Mr. Srivastava has represented Government of India in various high-stake matters, like the Vodafone International case for indirect taxation, like the LG Electronic case for AMT matters. Recently, Mr. Srivastava was part of the 6-member direct task force which drafted the Direct Tax Code bill, and that bill is currently pending with the Government of India for consideration. Now, directly, let's come to the topic. And Mr. Srivastava, welcome you on this show. And I would request you to kindly take us through the changes brought into Section 6 in brief.
So, to really understand the import of the changes made in Section 6, we must very briefly go through what the existing provisions were at the point of amendment. Now, we are confining ourselves today to only the individual taxation and residence of an individual. So, for the individuals, the test of residence given in Section 6 was primarily his physical stay in India for more than 182 days. If that condition is satisfied, he becomes a resident. An alternate condition was, and that exists today also, that if he is in India in the given year for a period of 60 days or more, and has been in the last 4 years in India for a total period of 365 days or more, then he would be regarded as a resident of India. There are certain categories of persons were kept out of this alternate condition by raising the limit of physical stay in the given year from 60 days to 182 days. Another important aspect of the existing law is that resident has two categories: not ordinarily resident and resident being ordinary resident. So not ordinary resident is a person who has been non-resident in 9 of 10 preceding years, or in the alternative, he is in India for less than 729 days in the last seven years. So that's the existing law, and this importance, the implication of being non-resident, not ordinarily resident, is that whereas a resident is charged to tax on his global income, a not ordinarily resident person, though being a resident, is charged to tax only in respect of his income accruing or arising in India, received or deemed to be received in India, deemed to be accrue or arise in India, or income which is derived from a profession set up in India or a business carried on from a country having a control in India. So he is not taxed on his global income as such. That's the critical difference. Now, what the amendment does? Amendment for the first time introduces a threshold of 120 days, for minimum threshold of 120 days instead of 60 days for those persons who are citizens of India or persons of Indian origin who come on a visit to India during the year. So earlier they had to be in India for a minimum period of yeah, 60 days or more. Yeah. Now, if they have income above rupees 15 lakhs from Indian sources, then they would be regarded as residents of India if they have a stay of 120 days in India, or if they have so in other words, I would say, put it simply, that threshold of 182 days which was there as an exception to them has been reduced to 120 days.
Very well, sir.
So they can, yeah. So it's to simply put, instead of going into, so if that be the case, then they would be, but if they have income less than 15 lakhs from Indian sources, then obviously no change for them. That provision of existing threshold of 182 days continues to apply, and they'll not be, that alternate condition will have no implication for them. Second very major amendment is about those persons who were seeking to claim are a status of not being resident of any other country in the globe, in the whole world. That means they could stay for a few months here and few months there and avoid a period of 182 days in any given country. So for them now the condition is that if he is a citizen of India, he has an income from Indian sources exceeding 50 lakhs, and he is not liable to tax in any other country by reason of his domicile or residence, then he shall be deemed to be a resident of India. So what is the impact of this? Impact is that a citizen of India having income of over 15 lakhs from Indian sources cannot now claim to be resident of no country. He will be deemed to be a resident of India, of which he is a citizen. But if his income is less than 15 lakhs, then that option which was available to him of managing his stay and not paying tax in any country on his global income could be avoided. And lastly, these two categories of persons who have suffered the amendment, that means the Indian citizens or persons of Indian origin who come on a visit to India, for whom the threshold has been reduced from 182 days to 120 days, there being income of over rupees 50 lakhs from Indian sources, and persons not being resident of any other country and being citizens of India, and again having income over rupees 15 lakhs from Indian sources. For these two categories of persons, they have been put in the provision governing conditions of not ordinarily resident. That means these two categories of persons would be recognized as NORs, and they will not be ordinary residents. The implication being that they would not be taxed on their global income, but they would be taxed on Indian source income received, deemed to be received in India, accrue or deemed to accrue in India, or the income which is derived from profession set up in India or from a business controlled from India. So short of that, so if that be so, then they would be charged to tax on that income and not in respect of all other global income. That is the implication of being categorized as NOR. These are in short the amendments.
This is very interesting, sir. Now we have brought in citizenship as a condition for determining the residential status. Sir, are we going the US way, where a citizen or a green card holder become resident and liable to pay tax on the global income?
Not exactly. Yeah, you may be right to the extent that citizenship has been introduced as one of the conditions in the determination of residence for the first time in India. US had it all along, but now in India, as the provisions finally enacted indicate, that a person is his residence is determined qua the person as also qua his income. So the two criteria, income being more than 15 lakhs from Indian sources, and he is a citizen of India. So if his income is less than 15 lakhs, citizenship has no relevance. But if his income exceeds 15 lakhs, then he falls into that category, being a citizen, to be regarded as a resident of India if he is not a resident of any other country.
Understood. Thanks, sir. Sir, my next question is that, as per my understanding, this deemed residency clause, which you just explained, this has been brought in to tax the stateless people, as it was explained in the finance bill as well by the Honorable Finance Minister, that there are many wealthy people who manage their stay in India in such a way that they do not breach the threshold of 182 days or 365 days, and they are not liable to pay tax in India, and they might not be liable to pay tax in any other country as well. So, this is a step in the right direction by the government. And why there is so much noise about this particular provision?
Yes, I mean, this issue of stateless persons, this is not an India-specific issue. This is bothering the tax administrations all over the world. So this abuse needed to be curbed, and to that intent in mind, I think the provisions were introduced. But now, finally, they have been enacted after the government amendments. So two categories are introduced. So noise now is by only those people who derive income of, say, 15 lakhs or more from Indian sources and are citizens of India, correct? But they were hitherto in a position to avoid their residence in India by managing their stay, but now they would not be able to manage. So that's the reason why there is so much of talk about it, but it's a step in the right direction, no doubt about it.
So we will now levy tax on such stateless people, but still there is an income threshold of 15 lakh. Sir, I have my next question with respect to this income threshold of 15 lakh. It's very common for the NRI community that they earn money abroad and remit that money to India and deposit that money in fixed deposits of Indian banks and earn interest income. For this 15 lakh threshold, will that Indian interest income be also included, sir?
See, any income derived or any income arising or accruing from a source in India, whether it be income accruing or arising in India, or deemed to accrue or arise in India, or income received in India, all that will come into that basket of Indian income. So any interest received on fixed deposits or any kind of those investments, if not exempt under any provision of the Act, would be included in the basket.
This will have implications for the NRI community. Sir, the next condition for this deemed residency clause, you said that that person should not be liable to pay tax on his foreign income because of domicile or residency. Sir, kindly explain in detail what are the implications of this provision, and can you, if you could give some examples of what would be the incomes which would fall under this category?
So this newly introduced provision, Section 6, subsection 1A, the third condition of that provision is that he is not liable to tax in any other country by reason of his domicile or residence. Now, a person is taxed in a foreign jurisdiction on his income, which is from the sources in that located in that country. For example, if I have a bank account in London and I get an interest from that bank account, I'll be liable to tax in UK for that interest income, subject to the whether under the domestic law of UK or under the treaty law, whatever be the rate. but that would not be a tax. My liability to tax will not be by reason of my domicile or residence in UK, but by reason of that interest be accruing or arising in UK. Right. So I'll not be a resident of UK. I'm not taxed because I'm a resident of UK, but I'm taxed because being a non-resident for UK is still I'm having some income arising or accruing in UK. So therefore the third condition would apply only in such cases where the person is not liable to tax by reason of his domicile or residence. So in other words, simple words, we can put it that unless he is a resident of some other country, this condition would stand fulfilled, despite the fact that he may be paying taxes in that country on the income derived from sources in that country.
Oh, that's enlightening for me, sir, that even if a person is paying tax in a foreign country on a foreign sourced income, and that because of the source rule, even then he will satisfy this condition. It's very interesting, sir.
Because the condition says that he is not liable to tax by reason of his domicile or residence.
Right.
That's the language.
That's interesting. Sir, next is this deemed residency clause. You did mention at the beginning that these deemed resident will become not ordinary resident. If you could explain the implications of this and why it has been so that they will be treated as not ordinary resident.
Yeah. So subsection 6 of section 6 defines non-resident, not ordinarily resident. Right. Now, when these provisions were introduced in the finance bill, these were as such. This provision was introduced 618. Now, this income criteria has been introduced at the time of the final passage of the bill, and now they are also categorized as not ordinarily residents. So what happens that suppose a person of Indian origin who came on a visit to India, and he settled in India for the future years. So for a few years, say 4 years or 5 years, he was NOR and did not pay tax on his global income, but only on the foreign source, the Indian source income and profession or business. But after the passage of that 4 or 5 years of that period, say 9 out of 10 years, and that those two conditions, once they got satisfied, then he became resident, ordinarily resident, and paid tax on his global income. Now, but these categories of people now, citizens of India who are either are persons of Indian origin, they are now categorized separately as not ordinarily residents, irrespective of the period of their stay in the past for any given year. For any given year. So what is their status, residential status in the past is not material, as in the case of other residents. So therefore, they would continue to be regarded as NORs till, I believe, perpetuity. And I'm pretty certain that this cannot be the policy intent. So maybe that we may have to wait for some more clarifications to come. So not for examining on year-to-year basis the residential status, we have to look whether a person has been non-resident in earlier years or he has been resident in earlier years. Now, that condition not being applicable to these two categories of persons, deemed residents and Indian citizens and PIOs coming on a visit to India, the language as it stands, it is giving them a position as if they are going to be NOR in perpetuity. And that's a highly doubtful whether that is the policy intent.
That's very interesting, sir. So you did mention that these deemed residents will might become, as per the law which has been introduced, they might become not ordinary resident in perpetuity, and there is no period threshold for these kind of people. So does this mean that an Indian who has always been staying in India and he's earning income in India more than 15 lakh, that Indian will also become not ordinary resident and he will not be liable to pay tax on his foreign income, being a NOR? Is it intentional or unintentional fallout of this provision, sir?
I don't think this can be intentional, but there is a fallout for the reason that the new provision of deemed residence begins with a non-obstant clause, and that clause said notwithstanding anything contained in subsection 1, and subsection 1 is the section which provides the primary test of being physical stay of 182 days in India. So if that section is overridden and that Indian citizen fulfills all the three conditions, he is a citizen, he is not liable to tax in any other country by reason of his domicile, and he has income from Indian sources over rupees 15 lakhs. So the provision of 6.1a applies to him with full force, overriding 6.1. So his physical stay becomes irrelevant once he becomes a deemed residence. So that would be the implication of the language as it stands today. I don't see that should be the policy intent, but yes, I cannot really comment that what is the intent of the government. But yes, the language does give a chance to the other people, as you said, to claim that they are deemed residents under 6.1a, and by virtue of being deemed residents, they ought to be categorized as NORs and get that benefit till all times to come.
So it's very interesting the way the law has been drafted. So friend, that's it. We had to discuss about the changes in Section 6 of the Income Tax Act with respect to the residential status of an individual. For the first time, citizenship and income threshold have been brought in as condition to determine the residential status. Hope you like this video, and we would like to thank Mr. G.C. Srivastava for sharing his view in so detail to explain these provisions to us. And friends, keep on watching our videos. We'll come up with some more videos on hot topics under Indian taxations. Till then, stay safe, stay inside. Thank you, sir.